The Philippines unilaterally initiated the arbitration at The Hague in 2013. Its 15 submissions raised in the arbitration can be categorized into three groups: challenging China's South China Sea dashline, China's claim of rights over several islands and reefs, and that China's exercise of rights on the waters harms the Philippines' interests. But one expert says underneath the submissions raised by the Philippines is a case concerning territory and maritime delimitation.
First, it focused attention on 9 ocean features actually owned by China. Not all of them are controlled by China. The Philippines controlled some of them illegally. But its illegal occupation of the features is not mentioned, as if this is not a problem. So primarily, it intends to deny China's sovereignty on the rocks, including low tide elevations.
Having identified the nature of the arbitration, experts talked about whether the tribunal has jurisdiction. The United Nations Convention on the Law of the Sea, or UNCLOS, doesn't cover territorial sovereignty, even if it involved maritime delimitation. According to Article 298, China has ruled out the settlement by compulsory arbitration.
So far, out of the 5 permanent members of the UN Security Council, 4 have similar rule out. The last one, the US, is not in the convention. The rule out itself tells of the international community's stance on dispute resolutions. On the third-party intervention on dispute resolution process, this was quite controversial at the Sea Convention conference. That's why there are so many limitations on it.
And on the tribunal itself, experts say it has strong political and temporary features. Unlike other maritime courts, which have 21 judges from countries and regions all over the world, the temporary tribunal only has 5 people. The presiding arbitrator, Shunji Yanai, once suggested to Japanese Prime Minister Abe to lift the ban on collective self-defense, and he was the only one who appointed the other 4 members.
It's easy for manipulation to take place, from the beginning of the case to the appointment of member arbitrators. The rules of this case is made up by the case itself. Other maritime tribunal or courts all follow fixed rules. It's such an important matter, yet it's put into hands of only 5 people.
Gong Ying-chung also said the tribunal violated the UNCLOS regulation on starting compulsory arbitration process. Its act exceeds authority, and the act itself harms the convention.